and welcome to my world. It's been a minute since I did a video, but this time I wanted to talk about traffic violations and why are we being arrested for such when they are not crimes. So let's begin. First we're going to start off with Rosenblatt versus California State Board of Pharmacy to describe what a license is. A license is a permit for considerations to a person, firm, or corporation to pursue some occupation or to carry out some sort of business. So if you're driving your car, are you doing any kind of business or operating any kind of employment that will gain you wages or profits? No. So why do you need a license? San Francisco versus Liverpool. A license are for the conduct of a business, profession, occupation, the exercise of which is a privilege. They give you a license because it's a privilege to make money over their highways. But it's not. It's a right to travel on the highways without a license. A license is a special privilege to do something that would not be entitled to do so without it. Washington RCW 46-25-050. Driver licenses are for commercial use. It's for doing business, making a profit or wages, like a Uber, taxi cab, truck drivers. Anybody that's making money over the highways would need a license. People versus Henderson. A license is their permission by competent authority to do an act that without permission would be illegal. Do you need permission to drive your vehicle, your automobile? No. Title 49 Idaho Code. Driver licenses are permit issued by the department of any other jurisdiction authorizing an individual to operate a motor vehicle or commercial motor vehicle. A driver's license is a permit to operate a motor vehicle. Now, motor vehicle and automobile are two different terms. They mean two different things, and we'll get into that. Article 1, Section 10 of the U.S. Constitution prohibits the state. Let me back up. City of Salina versus Wisden. The driver license, its rules, regulations are by legal definition a title of nobility, which grants privileges to citizens. And according to the U.S. Constitution, that is illegal. Article 1, Section 10 of the U.S. Constitution prohibits the states from granting titles of nobility. The court lacks subject matter jurisdiction to enforce upon the defendant titles of nobility. The definition between motor vehicle and automobile. Your motor vehicle is used for commercial purposes, to transport passengers and or property. The definition for automobile is used for personal business, leisure, not for profit. So you drive a automobile. You do not operate a motor vehicle because you are not driving for profit. Okay, so why do we need a license? Okay, a driver is employed in conducting a coach, carriage, or motor vehicle. It's Bowier's Law Dictionary definition. A traveler is one who passes from place to place for pleasure, business, personal business, health, or instructions. Lockett versus State. That's Alabama State. City of Dayton, Ohio versus DeBrosse. Motor vehicle is a term different and broader than the word automobile. And we just said automobile is for recreational purposes, not for gain. And knowing these two definitions and the difference in them makes all the difference when you're speaking law. And also, if you didn't see my video on what's different in the difference in lawful and legal, you need to check that out too. We're in two different worlds. We're in a legal and a lawful world, and we're using these terms because they mean different things in different arenas. So Delaware versus Pross. 1979. A person driving an automobile cannot be stopped to see if she or he has a license. You cannot be stopped to see if you have a license. Those checkpoints and those roadblocks, those are illegal. California Motor Vehicle Code, Section 260. Private cars, vans, RVs, etc., not in commercial use for profit are immune to registration fees. They are not commercial vehicles. They are immune from registrations, which means your tag. They are immune. We're not, why are we paying for tags? We're not doing commercial, we're not making money or profit over the highways. Why? Bank of Boston versus Jones. Vehicles not used for commercial activity is a consumer good, and it is not a type of vehicle required to be registered. Listen to this again. Bank of Boston versus Jones. A vehicle not used for commercial activity is a consumer good, and it is a type of vehicle not needing to be required, is not required for registration. Hendricks versus Maryland, 1915. A state may restrict the use of its highways to drivers who have complied with the license, insurance, and registrations. So if you comply, meaning you agree to somebody's wish, request, demand, conditions, or requirements, if you comply, you agree to them, then now the state has the right to restrict the highway and its use to you because you have complied to using its codes, its permits, its licenses, insurance, and registrations, which we have seen so far you do not need unless you're making a profit over the highways. So why are we all spending money on license, registrations, tags every year? We are being bamboozled into a system that is now based up on statutes and codes and not common law. Okay, let's look at another definition. Commercial motor vehicle. 1. The term commercial motor vehicle does not include the following. It does not include a mobile home to transport a house for non-business personal possessions or your family members. And it does not include a recreational vehicle operated solely for personal use. Let's look at State versus Johnson. Supervision officers must exempt persons when the transportation is not a commercial is not on a commercial basis. They must exempt them from registration. State versus Johnson. Officials must exempt anyone that is not operating commercial on a commercial basis from registration. California, this is my favorite. California versus Farley, 1971. Speeding, driving without a license, wrong plates, no plates, etc. are non-arrestable offenses. I was arrested because I didn't have a license, tag, or insurance. I had nothing. But I was arrested, which was not a crime. I was not committing a crime. I was maybe violating a code or an ordinance or a rule. But I was not breaking a common law because I had injured no one and I had damaged no one's property. Nevertheless, I was arrested because they do not want you to go up against the system. People versus battle. Traffic violations are not crimes. Why are they arresting any people who are not committing crimes? It's not a crime. Shearer versus Cullen. For a crime to exist, there must be an injured party, some kind of damages. Okay. When I got to jail, I said, well, who is suing me? Who did I hurt? What damages property did I damage? What have I done? Who is bringing me charges up against me? The judge or the magistrate, because she couldn't have been a judge, said that the city, the people of Georgia was bringing me to court. And I said, well, I need names and I need to see injuries. I need to see some blood. I need to see what harm have I caused. There was none. So there was no subject matter. You are just taking me to jail for no reason. Okay. You might want to ask that too if you're ever in that situation, and ask to speak to the prosecutor. Say, look, who is suing me? It cannot be an entity. It cannot be a corporation. It has to be a living person. Okay, it cannot be the state, the people of the state. That's artificial. It has to be a real living human that is bringing these charges and suits up against you. So Texas Penal Code, the people can only commit common law crimes, not civil statute violations. And that's what that is. And note, statutes, codes, ordinances are not laws. Traffic citations are codes, not laws. It's legal for them to arrest you, they did it, but it's not lawful according to the Constitution. Article 6, the Supreme Clause. Officers of the United States must hold this document supreme over all other laws, regulations, codes, orders, everything. The Constitution is supreme. Okay. Owens versus Independence. Officers of the court have no immunity when violating a constitutional right from liability. They are deemed to know the law. You can sue an officer for violating your constitutional rights. And in most cases, they do not know the Constitution, so they don't know that they're violating your. Most of them don't know what rights that they're violating or not. And if they do, then most of them don't care because they still throw you in jail because of that racket and that scheme. People versus Horton. The right of a citizen to drive on public streets with freedom from police interference, unless engaging in suspicious conduct associated with criminality, is a constitutional right and must be protected by the courts. So those roadblocks and point checks are illegal. Now, it says that you have the right to drive on public streets without public interference, unless some suspicious conduct is associated with it. I was pulled over because I didn't have a tag on my car. I asked what was probable cause. The officer said that the car could have been stolen. I said, well, did you receive anything on the radio that said it was stolen? Because I knew it was my vehicle. Of course it wasn't stolen. But that was the probable cause for them to take me in and to check if I had insurance, to check if I had all these other documents that they wanted me to have. State versus Robinson, Atlanta, Georgia. Illegal arrest is an assault and battery. Every time you are illegally arrested, it's an assault and battery. And you can file charges against the officers. Routh versus Quinn. No duty lies to apply for a possession of driver licenses for personal travel and transportation, as it is not within the class of persons for whom benefits it. So it says no duty applies. You don't have to have the possession of a driver's license for personal travel and transportation because it does not apply to you. You are not a person who benefits from having a license, who makes money on the highway. You're not a truck driver. You're not an Uber. You're not a taxi. You're not a chauffeur. You're just a person. You're just using the highway for personal use. Dickey versus Davis, 1915. The right of a citizen to travel upon the highway and to transport his property in ordinary life and business differ from one who makes the highway his place of business for private gain and wages. Once again, taxi drivers, Ubers, and truck drivers. It's a difference. Rockenbrod versus Mullins, Utah. A state cannot impose restrictions upon the acceptance of a license that would deprive the licensee his constitutional rights. When you get a license, you turn your rights into privileges. How did we get so messed up into that? The state cannot impose these things up on us. We have just agreed to do these things, and once you do not agree, now because everybody is doing it as a collective society and as a whole, the one person that does not do it now is thrown in jail. I didn't do it and I was thrown in jail to be made as an example. But if we all learn our rights and live up to them, then we would no longer be having to pay for a tag, title, and registration for purposes we do not use them for. Chicago versus Collins. A right which is free and open to all is not subject to a license or tax. It's your right to travel on the highways, which is a highways are public. It is our right, and it's not subject to a license. Miller versus U.S. To make a claim of a constitutional right cannot be converted into a crime. So you can say that claim all your constitutional rights, and they cannot convert them into a crime and say, oh well, you still, they will though. Let me just, that's what's so frustrating about learning law, is that you can see how much crime and how much in slavery and debt that we really are, and how the other lawyers and the other people who have learned these things, who know these things, are not sharing them with us, or making or teaching us these things. And that's why I really wanted to share what I'm learning a little bit more. Let's go into WW Cargill Company versus Minnesota. The acceptance of a license in any form will not impose upon the licensee an obligation to respect or comply with any provisions. So, okay, you already got a license, you already got your permits. That's not an obligation to comply with anything else if it goes against the Constitution. If it goes against the Constitution, you do not have to comply with it. Michigan versus Duke. State police power exists only to immediate threats to police safety, health, and welfare, of which driving and speeding are not. They have made traffic their main concern, but that's not a crime. Their main concern should be immediate threats to public safety, health, and welfare. Okay, so you are going five or six diameters over the speed limit. You get pulled over for that. What crime have you committed, really? Stevens versus Benford, 1932, or Packard versus Banton, 1924. It is established that highways are public property. Their main and preferred use is for private purposes. Their use for gain is special. So if you out there making money on the highways, that's a special privilege that you get, and you have to get a license to do that. Otherwise, you do not, because it is public property preferred for private purposes. The term traffic, the term is referring to business, not mere travel. Traffic is business related, and it is a privilege. You're doing commerce, trade, sale and exchange of merchandise, bills, money, or anything related to that, or passing goods or commodity from place to place for wages. That is the term traffic. So you're never in traffic if you are not engaged in some kind of commerce. Now, operator, person licensed to have a car on the street for business. You're an operator. You're making money you're operating a vehicle on a highway for business or for hire. You can also be a driver, but a driver is one who drives a car for personal use. So these terms, they seem like they mean the same, but they don't. You're an operator making money. You're a driver for driving for personal use. But a driver can also be an operator. A traveler, Lockett versus Alabama State. One who passes from place to place, whether for pleasure, personal business, health, instruction, or etc. So you're a traveler. Okay, traveling, a person who passes from place to place, whether for pleasure, personal business, health, or instruction. You're not making money on the highways as a traveler. Connor versus Commonwealth. To protect the personal liberties of citizens from unlawful arrest is the law that no person can be imprisoned for an alleged crime unless the oath of a competent witness. You got to have somebody come in and say you did something in order to be arrested. And most time it's an officer, but that's like playing the dozen, because you're on that side, the side who is on the side who's trying to sue the defendant. So you're not really a unbiased witness. And for a crime to exist, there has to be injury. A crime is an injury done with intent, not an accident. No injury, no crime. No property damage, no crime. Your driver license exempt code in Alabama, Title 32, says that commercial driver license requirement exempts. No person may drive a commercial motor vehicle on the highway unless that person holds a commercial driver license. Commercial driver license requirements do not apply to drivers or travelers of automobiles for recreation. Okay, I live in Alabama. That's the code right there. It says that it do not apply to drivers or travelers of automobiles for recreation. I drive for recreation. I do not make money on the highway. So why am I forced to get a driver's license? Thomas versus Smith. The right of the citizen to travel upon the highway and transport his property is not a mere privilege which can be prohibited or permitted at will. It is a common right of your life, liberty, and pursuit of happiness. It is your right to be able to travel on the highways and travel and transport your property if you're not making a profit off of it. It's your right. Let's get into registration, your tags. Bowman versus Kansas City. Bowman versus Kansas City makes the difference between motor vehicles and a private motor vehicle or automobile. There's a difference. A motor vehicle is for money, automobile is for recreational use. And your recreational vehicle does not have to be registered. California Motor Vehicle Code Section 260. No registration for private cars, etc. Not in commercial use for profit are immune from registration fees. A commercial vehicle is a vehicle used for profit, a type required to be registered. B, passenger vehicles not used for transportation of persons for hire, compensation, or profit. House cars, RVs, etc. are not commercial vehicles. They do not require a registration. Bank of Boston versus Jones. Exempt. 1. Any vehicle driven or moved on a highway relating to manufacturing, dealers, or non-residences. Say like it's a mobile home on the highway going from one state to another state, from place to place. You don't have to put a registration on that because you're just moving that trailer from one place to the next. Or it also says any vehicle driven only for the purposes of crossing highway from property to property. So I'm just moving my truck over here to my other land. You're not really driving it. You're just going from one place to place. You don't need a tag for that. And also not driven or moved for transporting persons or property for profit. So if you're not driving or transporting a person or property for profit, you don't have to have registration. Why is everybody going around buying tags? They're forcing us to. We're being bamboozled into this thing. And like I said, if the first time that you don't, you'll be arrested. But why? It's against your constitutional rights. All these rulings were didn't come about for no reason. They came about because someone took them to court and the law found them to be lawful. Let's talk about insurance for a minute. Mutual of Inumclaw versus Wiscombe, 1980. Insurance contracts are private businesses between two parties. That's between you and your insurance company. So a police officer really doesn't have the right to ask you anything about it. That's not his business. RCW 46-29-060. Financial responsibility is need not be provided until an accident has occurred. You don't have to show any proof of anything until an accident has occurred. So them pulling you over in these stops, checking your registration, license, driver license, insurance, those are things that are illegal because they don't have the right to know that I have not caused an accident. Why do you need to know if I have insurance? That's not your business. Okay. Also, Royce versus Bolt. The statute does not impose its requirements as to proof of financial responsibility until the occurrence of certain accidents, convictions, or bail forfeits occur. So you don't have to ask me for any proof of financial responsibility until certain things have happened, which is an accident, convictions, or bail forfeits, or something like that. Miller versus Aetna Life and Casualty. And also Mutual of Inumclaw versus Wiscombe. The Act does not require mandatory insurance coverage. This law does not require mandatory insurance coverage. It's not mandatory. And also the Financial Responsibility Act does not require an individual to prove coverage unless in an automobile accident resulting in $300 or more, or in injury or death. So if you have caused an accident that costs less than $300, say you just got a little scratch on somebody, you don't have to show insurance. More than likely because you can come up with $300. So you don't have to prove that you have insurance for that. But anything over that, injury or a death, you want to be able to prove that you have something. But you don't even have to have insurance from an insurance company. You can have already saved up your own money and start your own insurance way of being able to pay outside for anything like that. LaPointe versus Richards. The existence of an insurance policy is a matter of contract law, since insurance involves a contractual relationship between the insurer and insured. That's your private business. That's not the business of any cop or any kind of officer or anybody else is asking you about your contractual business with this company. State versus Benzel, 1998. A court cannot acquire jurisdiction to try a person for an act made criminal only by an unconstitutional law. So they're going to make all these unconstitutional statutes and things and then arrest you. They cannot do that. An offense created by an unconstitutional statute is no longer a crime. It's not a crime, and a conviction under such statute cannot be legal because it cannot be a legal cause for imprisonment. How many times you've gone to jail for a statute or rule or ordinance? Something that was against the Constitution, but you still had to go like traffic tickets. They're not crimes. They're not even in the Constitution, but you are still arrested. You have the right to travel without these things. And you're not to be arrested unless you have committed a crime, not violating a statute, rule, or an ordinance. Okay. Attorney General's annual report in 1909, New York, Albany. There is no requirement that the owner of a motor vehicle shall procure a license, nor is there any other person to do so, unless he proposes to become a chauffeur or a person conducting an automobile as an employee for hire. Same thing we've been saying. If you're not working for hire, what do you need a license for? What do you need registrations for? Robinson versus State. Where no crime exists, the court lacks a subject matter jurisdiction to render a conviction. It is powerless to apply law and to declare punishment. You haven't committed a crime, so they do not have subject matter. What am I here for? They don't have subject matter jurisdiction to even give you a conviction or to apply law for punishment. It's not even real court, and we'll get into what colorable court means in another video. It's not even real court. Now let's get into an injured party. Again, is the accuser must have a name or an appellation. A human being must make the accusation. It can't be an agency or some kind of institution. It can't be the people of the state. And there has to be evidence, not hearsay. It has to be direct evidence. You need to see blood. You need to see whatever, the crash. You need to see something that shows that who's at fault. Violators of civil statute codes include inanimated entities like corporations, legal fictions, and actors, but it does not include human souls or living souls. Codes include traffic infringements and anything that is not under common law. So anything without an injured party would be a statute or a code. So we need to start claiming our rights as living souls and not the straw man, because they can only do business with the straw man, which is your corporate person on paper. So that they can only do business because they are a corporate person on paper. So they can only do business with our straw man. Once we start claiming that we are living human souls with blood running through us, we are alive, and we do not represent the straw man, they cannot do business with us. We do not contract under that quote name. And we have an appellation. Now, I think I had that in another video. Check out all my videos, especially on law. And I'll keep up. I'll make sure I do another video, and we'll talk a little bit more about names and appellations and the straw man a little bit more too. Hope you enjoyed this video, and ask yourself, why are you getting a driver's license when you're not operating for hire, making any kind of wages on the highway? Why are we getting registrations and tags? And why are we being arrested for traffic violations when they're not crimes? Okay? Until next time, love and peace.